Lichtwick matter, the appearances are the same. Standby counsel is present again in the courtroom. I have been advised that we have a verdict from our jury. We will bring the jury in. Do you have those final answers? Thanks. Yeah, you don't even have to do 525. Just is the 522 just the poll? Yeah. Yeah, please.
All rise for the jury.
Thank you. You may be seated. I have been advised that the jury has a verdict. Is that correct? Is Mr. Morotek the jury foreperson?
Yes.
Okay. Could you please hand the folder to the bailiff? The court will now read the verdict. In the matter of State of Wisconsin versus Kevin Lychwick.
This is the moment every courtroom watches in complete silence. Weeks of testimony, evidence, and deliberation all come down to a few pages inside that folder before we hear the verdict. What do you think the jury decided based on the evidence presented?
Verdict as to count 1. We, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information, signed and dated this 11th day of June, 2026, and it bears the foreperson's printed name and signature. Verdict as to count 2. We, the jury, find the defendant, Kevin W. Lychwick.
And there it is, a guilty verdict on first-degree intentional homicide and hiding a corpse. Notice that the judge specifically notes the other verdict forms were left blank. That's standard procedure when jurors reach a final decision on the primary charges. In just seconds, the legal uncertainty that existed throughout the trial has completely disappeared.
Guilty of hiding a corpse as charged in count 2 of the information, signed and dated this 11th day of June, 2026, again bearing the foreperson's printed name and signature. The other 2 verdict forms are left blank. Ladies and gentlemen, I am now going to do a process called polling the jury. It's going to ask each of you individually if these are your verdicts. I'm going to start in the back corner. Ma'am, are these your verdicts? Are these your verdicts, sir?
The jury poll may seem routine, but it's actually one of the most important safeguards in the justice system. Each juror must personally confirm the verdict in open court. Listen to how every answer is clear and consistent. No hesitation, no disagreement. That confirms the verdict was unanimous.
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, it is.
Are these your verdicts?
Yes, Your Honor.
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 Are these your verdicts?
Yes.
And are these your verdicts?
Yes, Your Honor.
Is the state satisfied with the polling?
Yes.
Mr. Lychwick?
I don't know what to say at this point.
Okay. The court has polled all individual jurors, and all jurors have indicated that these are their verdicts. Members of the jury, with the verdict delivered, your service in this case has concluded. Therefore, you may now freely discuss the matter with any individual of your choosing, and all of my restrictions on such discussions have been removed. However, it's important for you to understand that you are under no obligation to discuss this case or answer any questions about it unless I require you at some later date to answer questions about it. This applies to interactions with the parties, their attorneys, the members of the media, any other individuals. Should you choose to discuss the case with others, though, I urge you to approach these conversations with the seriousness that they deserve. I would also recommend that any discussions you engage in are ones that you would feel comfortable having in the company of your fellow jurors and openly in court under oath. While you have the right to speak freely about this case, it is important to remember that discussions in the jury room were conducted in an environment designed to be open and free from fear of reprisal or criticism. Your fellow jurors shared their opinions fully and candidly and may not want their opinions made public. Therefore, I urge you, when you discuss the case and discuss deliberations, you discuss those from your own viewpoint and not the viewpoints of your fellow jurors.
One detail many viewers overlook is the judge's message to the jurors after a verdict. Their job is done, but the court still encourages discretion and respect for the deliberation process. Jurors carry a tremendous responsibility, especially in a case involving the most serious charge in criminal law.
Finally, ladies and gentlemen, I have a couple of matters to still discuss with the parties. It'll take probably about 5 minutes or so. If any of you have any questions or feedback that you would like to give me, stick around in the jury room and I will come back and do my best to answer those questions if you have any. Otherwise, on behalf of Waukesha County, I extend my deepest gratitude for your service in this case. I recognize that you have devoted considerable time to this case this week, but your contribution is a vital component of our justice system as enshrined in the United States Constitution and our state constitution. So it's my hope that you have found this experience to be rewarding.
Now the case shifts into a new phase, sentencing. A guilty verdict answers a question of guilt, but sentencing determines the consequences. Since first-degree intentional homicide in Wisconsin carries a mandatory life sentence, the upcoming proceedings will focus heavily on release eligibility and other sentencing considerations rather than whether imprisonment will occur.
You are now discharged in this case. Thank you.
All rise for the jury.
Thank you. You may be seated. We are outside the presence of the jury. Attorney Thompson, any motions from the state?
I would ask that the court enter a judgment of conviction on each count.
Mr. Lychwick, are you moving for judgment of acquittal notwithstanding the verdict?
Yes.
Okay. The court will grant the state's motion and order judgments of conviction as to each count. Mr. Lychwick, I'll advise you that you are a convicted felon now, and as such, you may not use or possess a firearm for the remainder of your life. You also may not vote until your civil rights have been restored. We will schedule this case for sentencing. Attorney Thompson, do you have a specific length of time in mind as to how far out you want to go for sentencing?
I am not requesting a PSI in this case, so at the family's wishes, as soon as the court can accommodate, please.
Mr. Lychwick, there is a mandatory sentence of life imprisonment on count 1. The court does have the ability to determine early release, or eligibility for release, I should say. One of the options you can exercise for sentencing is a request for a pre-sentence investigation. The state's not requesting one. I don't particularly need one, I don't think. But if you would like one, we could order a pre-sentence investigation. Otherwise, I could offer a date as early as tomorrow for sentencing.
I would like a pre-sentence investigation, Your Honor.
Okay. I'll allow for the pre-sentence investigation.
The defendant's statement, I plan to appeal, signals that this case may not be over yet. An appeal is a new trial. It focuses on whether legal errors occurred during the proceedings. The convictions stand for now, but the next chapter can unfold in the appellate courts. Do you believe the verdict will withstand appeal, or do you see potential issues that could be challenged?
So we'll schedule the matter accordingly. That'll go out about 60 days, probably.
Thursday, August 20 at 8:30.
That
Okay.
works for the state. Thank you.
August 20 at 8:30 then. The court will order the PSI. The defendant is remanded into custody. And Attorney Galloway, the court is relieving you of your standby counsel appointment.
Thank you.
Anything else from the state at this time?
No, thank you.
From the defense?
I plan to appeal, Your Honor.
I understand you will have that right, and I will notify you of your opportunity to appeal after sentencing. We stand adjourned.